Criminal Due Process by Amelia Hempstead, Spencer Lesson, and Nishi Kadakia. An arrest is to seize someone by legal authority and take them into custody. When completing an arrest, the police must follow legal procedures, including telling you your Miranda rights. The reason an arrest will happen is when there is evidence against a person that he or she may have committed a crime. Booking is a phrase that refers to the recording of an arrested person's name, age, address, and reasons for their arrest. That person is then brought into jail and placed behind bars. Most times, if not all, the book is a computer. Also known as a probable cause hearing, the preliminary hearing determines whether there is enough evidence for the case to require a trial. This hearing occurs after a criminal complaint is filed, and the decision is reached by a judge after listening to both the prosecution and defendant's arguments. This probable cause decision is not determining guilt or innocence, but whether the case is strong enough to go to trial. The arraignment is the first courtroom-based proceeding in a criminal case. For the arraignment, the accused goes before a judge who first reads the criminal charges against the defendant. The judge then asks the defendant if he or she has or needs an attorney. The defendant is also asked how they have chosen to plead, either guilty or not guilty. The judge can then decide to alter the bail amount or allow the defendant to promise in writing to appear in court. This is also known as releasing the defendant on his or her own recognizance. Finally, the judge announces the dates and times of further proceedings. The prosecution will also provide the defense with evidence relevant to the case during the arraignment. Once the charges have been established and evidence has been shared, both the prosecution and the defense begin pretrial negotiations, reviewing the available evidence and deciding what can be proven in court. The prosecution then proposes a trade-off to the defense, and they can make a plea bargain, which requires the defendant to plead guilty in exchange for a less serious sentence. Most cases are resolved in this way, saving stress, money, and court time in the process. If the issue cannot be resolved in pretrial negotiations, the case will go further in the criminal process. A trial is the fact-finding phase of the criminal due process. It is held to determine if the accused is innocent or guilty. The prosecution is responsible for proving the accused guilty. The defendant is not required to prove his innocence or call or cross-examine witnesses and has the right to decide whether to testify or not. There are bench trials and jury trials. In bench trials, the judge resolves issues without a jury. In jury trials, the jurors solve disputes. In this stage of the case, the judge or the jurors determine if the accused is guilty or innocent. This is often followed by a sentencing phase in which the accused, if guilty, is punished for his or her crimes. An appeal is when one disagrees with the verdict and appeals to a higher court for a reversal of the decision of a lower court. Either side may appeal a civil case. In a criminal case, only the defendant may appeal of a guilty verdict. The government cannot appeal if a defendant is found innocent. However, either side may appeal with respect to the sentence that is imposed after a guilty verdict.